Case E-File 4471D. United States Department of Homeland Security. Homeland Security Investigations, in conjunction with Drug Enforcement Administration, HHS Office of Inspector General, Internal Revenue Service Criminal Investigation. Subject: reclassification of controlled chemical precursors via fraudulent customs brokerage. Total estimated import value, $640 million. Principal defendant, Victor Emmanuel Salcedo-Rios. Licensed customs broker, CBP license number 8844021C. Primary port of entry, Port of Long Beach, California. Case opened, March 14, 2019. Case closed. Indictment, May 6, 2021. Classification status, partially declassified, June 2023. This file has been declassified in part pursuant to the Freedom of Information Act. Certain witness identities, confidential informant designations, and ongoing law enforcement referrals remain redacted in the public release. What follows is the reconstructed record of how one man, holding a federal license and sitting behind a cluttered desk in a nondescript office building on West Anaheim Street in Wilmington, California, quietly dismantled one of the most effective chemical controls ever placed on the fentanyl supply chain, and how the federal government, starting from a single mismatched tariff code on a single shipping manifest, built the case that ended him. The Port of Long Beach processes roughly 9 million container units per year. That figure is not incidental to this file. It is the operating premise of the fraud. At that scale, the port functions less like a checkpoint and more like a river, a massive continuous flow of commerce in which any individual anomaly is nearly invisible unless someone is specifically trained to look for it, and unless that someone is looking at exactly the right data stream at exactly the right moment. Victor Salcedo-Rios understood that reality as well as anyone alive. He had worked the port system for 19 years before the first federal agent ever opened a file on him. He knew the rhythm of the inspections, the workload pressures on customs and border protection officers, the specific formatting conventions that caused manifest reviewers to move quickly past a line item rather than pause on it. He had, in other words, acquired a comprehensive map of the system's blind spots, and he had begun, sometime around late 2017, to sell access to those blind spots to people who very badly needed them. The people in question were affiliates of the Sinaloa Cartel's Chemical Procurement Division, a semi-autonomous unit within the organization responsible for sourcing, importing, and distributing the raw chemical compounds required to manufacture synthetic opioids at industrial scale. By 2017, fentanyl and its analogs had already begun displacing heroin across the American overdose landscape, and the cartels had identified the precursor supply chain as both their greatest opportunity and their greatest vulnerability. The United States had worked in concert with China, Mexico, and the European Union to schedule and restrict a core list of precursor chemicals. Acyl chlorides, piperidine derivatives, and particularly phenylacetyl chloride, the primary pathway chemical for the most common synthesis routes, faced tightening international controls. Getting those chemicals into the country in quantity required either corrupting a supplier, corrupting a laboratory, or corrupting the customs system. Victor Salcedo-Rios was the answer to option 3. Salcedo-Rios Freight Solutions, LLC occupied a suite of offices at 4417 West Anaheim Street in Wilmington, a community directly adjacent to the port. The company was licensed, bonded, and in good regulatory standing. Its website described a full range of customs brokerage services, entry preparation, tariff classification, bonded warehouse management, ISF filing, compliance auditing. It employed 11 people at its peak. It had a Google business listing with 4-star reviews, several of which praised the firm's attention to detail on complex chemical shipments. The firm's actual specialty, hidden within that unremarkable profile, was Harmonized System Tariff Code Manipulation. The Harmonized System, or HS Code, is the international numerical classification framework that customs authorities worldwide use to categorize every commodity crossing a border. Each code maps to a specific product category, and those categories carry corresponding duty rates, inspection requirements, and, crucially, regulatory flags. Chemicals subject to international precursor controls carry specific HS codes that trigger enhanced scrutiny. A shipment of acetic anhydride, for example, carries code 2915.24, a code that, when it appears on an import manifest at a major US port, is supposed to generate an automatic hold for verification. A shipment of certain agricultural solvents, by contrast, carries codes in the 2901 and 3814 families that generate no such flag. They are routine industrial commodities. They move quickly. What Salcedo-Rios had perfected was the art of filing the second kind of entry for the first kind of chemical. The process was meticulous. Incoming containers from a network of shell suppliers in mainland China, Hong Kong, and, in later shipments, Malaysia would arrive at Long Beach with documentation prepared by the originating broker, documentation that was itself fraudulent in origin but technically passable at first glance. Salcedo-Rios's role was to take that documentation and prepare the formal US customs entry, selecting HS codes that described agricultural or industrial solvents rather than controlled precursors, writing item descriptions that matched the fraudulent coding, and managing the cargo release process to ensure the containers cleared without a physical examination. His fee, according to evidence introduced at the subsequent federal proceedings, was structured as a percentage of the assessed duty avoided, a number that ultimately resolved to somewhere between $4 and $6 million over the full run of the scheme. The chemicals themselves were genuine. That was the perverse elegance of it. The containers actually held what they were supposed to hold: industrial drums of chemical compounds. The fraud was entirely in the labeling, in the paperwork, in the selection of HS codes that rendered those drums invisible to the regulatory systems designed to catch them. Once cleared, the containers moved on bonded transport to a network of warehouse facilities, including a primary distribution hub in Carson, California, and secondary sites in the Inland Empire and in the Central Valley. There, the drums were broken down, relabeled again, and distributed by cartel-linked couriers to clandestine synthesis laboratories operating primarily in Los Angeles County, Riverside County, and, based on wiretap evidence developed later in the investigation, at least 2 sites in the Pacific Northwest. The volume was extraordinary. Over approximately 31 months of confirmed operation, federal investigators documented the importation of at least 847 individual container loads attributable to the scheme, representing an estimated aggregate chemical weight in excess of 4,000 metric tons. To understand what that figure meant in terms of downstream consequence, investigators consulted with DEA chemists, who calculated that the documented precursor volume was theoretically sufficient to produce, depending on synthesis efficiency, between 60 and 90 metric tons of finished fentanyl, at average street potency and pricing circa 2019 to 2021. That represents a supply-side value in the range of $640 million, the figure that would eventually headline the indictment. The thread that unraveled it all began not with a tip or a surveillance operation or an informant, but with a spreadsheet. Special Agent Theodora Kwan was assigned to the HHS Office of Inspector General's Financial Investigations Unit, embedded within a joint federal task force focused on pharmaceutical supply chain integrity. Her primary mandate was healthcare fraud, billing anomalies, phantom prescriptions, diversion from licensed distributors. Fentanyl precursor imports were not her portfolio. They became her portfolio by accident. In January 2019, Agent Kwan was conducting a routine analysis of import tariff data obtained through a data sharing agreement between HHS OIG and CBP's Office of Trade. The specific dataset she was working with concerned duty exemptions claimed on chemical shipments from China and Southeast Asia, cross-referenced against DEA Schedule 1 and 2 precursor alert codes. The purpose of the analysis was to identify pharmaceutical distributors potentially importing precursors through manipulated entries, a known fraud vector in the pharmaceutical diversion world. Kwan was looking for patterns involving licensed drug companies. Instead, she found Victor Salcedo-Rios on entry number 4471D of her working dataset, the number that would eventually name the case file. She encountered an anomaly. A container of what was filed as 3814.00, 9050, a miscellaneous organic solvent preparation, had been entered by Salcedo-Rios Freight Solutions on behalf of a Chinese exporter called Guangzhou Jijia Chemical Trading Company. Limited. The container had been cleared at Long Beach on October 17, 2018. What caught Kwan's attention was not the HS code itself, but the declared unit weight in relation to the declared value. The specific entry claimed a weight-to-value ratio that, in Kwan's experience, was characteristic of certain chemical categories that carried higher duties under alternative classification, specifically categories that would have required additional documentation under the DEA's threshold reporting requirements for listed chemicals. She flagged it. She sent a query to CBP Trade Enforcement asking whether the physical examination on that container had been documented. CBP's response came back 48 hours later. The container had been released without examination. The CBP officer who processed the entry had flagged it as low risk based on the HS code, the importer's compliance history, and the broker's standing as a licensed bonded entity with no derogatory record. Kwan pulled the full entry package. The bill of lading, the commercial invoice, the packing list. What she found was a document set that was internally consistent and professionally formatted, but which, when she ran the declared chemical name against DEA's chemical control database, produced a mismatch. The chemical name on the commercial invoice, listed as Modified Polyol Blending Agent Industrial Grade, was a descriptor that did not correspond to any recognized chemical product in DEA's reference library. It was, in a technical sense, a name that sounded plausible without being traceable. It was designed to be filed and forgotten. She did not forget it. She pulled 12 more entries from Salcedo-Rios Freight Solutions covering the same 18-month window. 9 of them showed similar patterns, weight-to-value ratios and chemical descriptors that were internally consistent but technically unverifiable. She drafted a referral memo to DEA's Diversion Control Unit and to Homeland Security Investigations. The memo was 3 pages. It noted in understated federal bureaucratic language that the entries in question might benefit from further technical review. That memo, sent on February 28, 2019, was the first document in what would become a file running to over 40,000 pages. DEA Diversion Group Supervisor Marcus Prieto received Kwan's referral on March 4, 2019. Prieto, a 22-year veteran whose career had tracked the evolution of the synthetic opioid trade from precursor diversion through pill pressing through the current fentanyl era, understood immediately what he was looking at. The pattern Kwan had identified was consistent with a practice known within DEA's intelligence community as tariff washing, using fraudulent HS classification to strip controlled substance precursors of their regulatory identity at the border. Prieto had seen elements of the technique before. He had never seen it operated at this scale by a single licensed broker. He contacted HSI's trade fraud unit in Los Angeles. Special Agent in charge Rebecca Morales assigned the case to a 4-person investigative team led by Senior Special Agent Donovan Espinosa. Within 2 weeks, Espinosa's team had pulled the full import history for Salcedo-Rios Freight Solutions going back to 2015, cross-referenced it against DEA's precursor intelligence database, and identified a cluster of 63 entries that warranted priority analysis. The team also ran Salcedo-Rios himself through every available federal database: criminal history, financial records, known associates, travel history, property records, corporate filings. What they found was a man who, on paper, had lived an entirely ordinary life. Victor Emmanuel Salcedo-Rios, 44 years old at the time of the initial investigation, had been born in the Boyle Heights neighborhood of Los Angeles and had grown up in a household with deep roots in the import-export community. His father had worked as a freight forwarder for 3 decades. Salcedo-Rios had earned a degree in logistics management from California State University, Long Beach, obtained his CBP broker's license at 26, worked for 2 established customs brokerage firms for a combined 11 years, and launched Salcedo-Rios Freight Solutions in 2008. He was married, owned a home in San Pedro valued at approximately $890,000, had 2 children in private school, drove a 2019 BMW X5, and had a registered retirement account showing consistent contributions. The retirement account was the first crack. IRS CI analysts, brought onto the task force in late March 2019, examined Salcedo-Rios' reported income against his lifestyle expenditures and found a gap that could not be explained by the stated revenues of Salcedo-Rios Freight Solutions. The firm's tax filings showed annual gross revenues in the range of $2.10 to $2.4 million, plausible for a mid-size customs brokerage handling specialized chemical accounts. But Salcedo-Rios' personal expenditures, when totaled across mortgage payments, school tuition, vehicle leases, travel, and home renovation costs documented through contractor payments and permit filings, were running at an annualized rate roughly $380,000 above what his declared income could support. Somewhere between $350,000 and $400,000 per year in undisclosed income was flowing into his household. The investigators needed to find where it was coming from. The answer was in the shell companies. Between 2016 and 2019, Salcedo-Rios had established or acquired controlling interests in 7 limited liability companies registered variously in California, Nevada, and Wyoming. The companies held names that suggested freight, logistics, or consulting services. Pacific Rim Transit Services, LLC, Verimar Logistics Consulting, Inc., Caltrans Import Advisory Group, LLC, and 4 others. None of them had meaningful public business activity. None of them filed payroll tax returns. All of them held bank accounts at 3 different financial institutions. The financial architecture, once Espinosa's team and the IRS CI analysts mapped it in full, was a layered trade-based money laundering structure. The shell companies received wire transfers from overseas accounts connected to the same Chinese and Malaysian exporters who appeared on Salcedo-Rios' falsified customs entries. Those payments were described on the wire transfer records as consulting fees, freight coordination retainers, and sourcing commissions. The shell company accounts then moved funds through a sequence of transfers, typically 3 to 5 intermediary steps, before the money arrived in Salcedo-Rios' personal accounts or was used to pay his personal expenses directly. The structure was competently designed. It was not, as it turned out, competently operated. One of the Nevada shell companies, Pacific Rim Transit Services, LLC, had been receiving wire transfers from a Guangzhou-based entity that appeared on DEA's Financial Intelligence Watch List, an entity with documented associations with a Sinaloa Cartel-affiliated chemical broker named in a 2016 El Paso Intelligence Center assessment. The connection was thin, circumstantial, and not immediately actionable, but it confirmed the investigative team's working hypothesis. Salcedo-Rios was not freelancing. He was operating as a contracted service provider within a larger cartel procurement infrastructure. By late June 2019, the task force had enough to open a Title III wire intercept application. The application, prepared by the U.S. Attorney's Office for the Central District of California and reviewed by DOJ's Organized Crime and Gang Section, ran to 112 pages. Federal District Judge Constance Harrington reviewed and approved the order on July 9, 2019, authorizing the interception of communications over 4 telephone numbers associated with Salcedo-Rios and 2 of his associates. The wiretap phase of the investigation lasted 14 months and produced over 18,000 intercepted communications, calls, texts, and encrypted messaging application content obtained through additional legal process. The material was processed by a team of analysts that eventually included Spanish language linguists, Mandarin language linguists, and, for a subset of messages sent through a cartel-affiliated encrypted communications application, a specialist unit within HSI's cyber division. What the intercepts revealed was the operational reality behind the sterile pattern that Kwan had first spotted in her spreadsheet. Salcedo-Rios was in regular contact with at least 3 cartel side coordinators, referred to in the Intercepts by the phonetically rendered Spanish nicknames El Contador, Marcos, and a third individual who appears in the Intercept logs only as El Señor de las Cajas, loosely, the Lord of the Boxes. Communications with these individuals covered shipment scheduling, payment arrangements, and, on multiple occasions, discussion of close calls with CBP inspection holds that had required Salcedo-Rios to intervene through his contacts within the port's release process. The Intercepts also documented something that the investigators had not anticipated: Salcedo-Rios' active management of the chemical distribution side of the operation within California. Several intercepted communications placed him in contact with individuals associated with 2 of the clandestine laboratory sites that DEA would later identify: a converted warehouse facility in the City of Industry and a residential compound near Hemet in Riverside County. These contacts were not passive. Salcedo-Rios was, in several intercepted conversations, actively coordinating delivery schedules for specific chemical lots, providing transport routing instructions, and, in one particularly significant exchange on November 14, 2019, discussing the quality testing results for a specific batch of chemicals against expected synthesis yield parameters. This was not the role of a customs broker who had simply sold his license to a third party. This was the conduct of a person embedded within the distribution network as an operational participant. The November 14th exchange would later be described by the prosecuting AUSA as the single most consequential piece of evidence in the case. It demonstrated, beyond the financial and documentary record, that Salcedo-Rios understood the end use of the chemicals he was importing. He was not a man who could claim that he had been deceived about the nature of his cargo. He knew exactly what he was moving, and he knew exactly where it was going. Physical surveillance of the Carson warehouse, the primary distribution hub identified from address references in the wire intercepts, began in September 2019. The facility was a 48,000 square foot industrial building on East Del Amo Boulevard, leased by a company called Western Pacific Cold Chain Solutions, Inc., yet another shell entity, this one registered in Delaware and connected through a nominee director to one of Salcedo-Rios' Nevada shells. The facility had a loading dock that accommodated tractor-trailers, a secure interior section with climate control, and what appeared from exterior observation to be a legitimate warehousing and cold storage operation. Surveillance agents documented truck movements in and out of the facility over a 6-month period. They tracked container chassis leaving the port of Long Beach and arriving at Del Amo. They photographed vehicle registrations, noting the recurrence of a specific set of commercial plates connected to a trucking company that, on paper, did routine dry goods hauling in the Southern California region. They coordinated with the Port Authority to obtain electronic container tracking data, which allowed them to link specific container arrival events at the port to specific truck movements to the warehouse, a mapping exercise that by February 2020 had produced a documented inventory of 114 container loads they could connect to Salcedo-Rios' fraudulent entries. In November 2019, with the investigation approaching its first anniversary and the task force preparing a mid-course assessment for DOJ, the team received a new intelligence input that significantly expanded their understanding of the network's geography. A cooperating source within a DEA case operating out of the Tucson Field Division provided information indicating that the Carson warehouse was not the only distribution point for the Long Beach chemical pipeline. The source described a secondary hub in the Inland Empire, later identified through surveillance as a facility in the city of Fontana, and mentioned that some portion of the chemical flow was being transported by commercial truck to Northern California and, on at least 2 documented occasions, moved by air freight to a Pacific Northwest destination that the source could not specify. The Pacific Northwest thread was referred to the Seattle Field Division of HSI, which opened a parallel investigation. That investigation remains partially active and is not addressed in this file. By the spring of 2020, the Carson surveillance team had accumulated enough physical evidence to consider a warrant, but the task force supervisors made the decision to hold. The financial investigation was still developing. IRS-CI analysts were working to complete the accounting on the shell company network, and the target figure, the $640 million import valuation that would anchor the indictment, was not yet fully documented. More critically, the wiretap coverage was still producing intelligence on the cartel side coordinators, and DOJ wanted to see whether extended intercept coverage might produce evidence sufficient to support charges against the overseas principals. The decision to hold proved consequential. On January 19, 2021, an intercepted communication between Salcedo-Rios and the individual identified as El Contador indicated that a cartel-side security officer had become concerned about possible federal surveillance of the California operation. The specific language of the communication, as translated in the intercept log, was indirect but unmistakable in context. The cartel security officer wanted shipments paused, the Carson warehouse cleared, and what the translation rendered as the paperwork man, a reference investigators assessed as pointing to Salcedo-Rios. To go quiet for 60 days, the task force convened an emergency session. The question was straightforward: move now or risk losing the evidence at the warehouse. The assessment from the DEA diversion supervisor was equally straightforward. If the warehouse was cleared, the chemicals would move into the distribution network, and the physical evidence linking the import pipeline to the synthesis labs would evaporate. They had the financial case. They had the wiretap case. They had the documentary case. They did not need 60 more days. They needed a warrant, and they needed it now. Federal search warrant applications for the Carson warehouse, the Fontana facility, Salcedo-Rios' office in Wilmington, his personal residence in San Pedro, and 6 other locations associated with his shell company network were prepared over a 72-hour period and presented to the duty magistrate judge on January 26, 2021. The applications totaled over 800 pages of supporting affidavit material. All 7 were approved. The arrest warrant for Victor Emmanuel Salcedo-Rios was signed on January 27, 2021. February 9, 2021, 4:30 in the morning. The sky over Carson, California was the particular shade of deep purple that precedes the pre-dawn gray, the port's light towers visible on the horizon 4 miles to the west. On East Del Amo Boulevard, 11 vehicles sat dark and idling in a staging arrangement that stretched 2 blocks in each direction from the entrance to Western Pacific Cold Chain Solutions. 31 federal agents from DEA, HSI, and IRS-CI were in the raid element, supported by 4 evidence technicians, 2 DEA forensic chemists, and a logistics coordinator responsible for managing the physical seizure of containerized chemical cargo. Senior Special Agent Donovan Espinosa was designated the on-scene commander for the warehouse operation. He had been awake for 26 consecutive hours. At 4:47 a.m., he gave the radio command that moved all elements simultaneously. The warehouse entry team was through the facility's main access door in under 40 seconds. The interior was larger in person than the surveillance photographs had conveyed. Row after row of industrial shelving stacked with blue and white plastic drums, each marked with the same generic modified polyol blending agent industrial grade designation that Kwan had first flagged in her spreadsheet nearly 2 years earlier. The facility's interior security was minimal. 2 men were present on the warehouse floor, both of whom were detained without incident. A third individual, found in the facility's small office area, attempted to contact someone on a cellular phone before agents secured the device. The phone would later prove to be one of the most significant pieces of evidence seized that morning. Simultaneous operations unfolded at the Fontana secondary facility, at the Wilmington office of Salcedo-Rios Freight Solutions, and at Salcedo-Rios' San Pedro residence. At the Wilmington office, agents seized 38 banker boxes of paper records, 14 computers, 12 external hard drives, and a floor safe that was found to contain $344,000 in bundled cash. A USB drive subsequently determined to contain encrypted customs entry records and a handwritten ledger. The ledger, 43 pages long in a spiral-bound notebook of the kind sold at any office supply store, listed container identification numbers on the left-hand column and dollar figures on the right. The dollar figures corresponded, with remarkable precision, to the commission structure that investigators had reconstructed from the shell company wire transfers. Salcedo-Rios had, for reasons that his subsequent defense attorneys were unable to explain satisfactorily, maintained a personal accounting record of his criminal enterprise in a spiral notebook in a floor safe in his own office. At the San Pedro residence, agents encountered Salcedo-Rios himself. He had been under mobile surveillance since the previous evening, and agents had tracked his location to his home as of 11 p.m. the previous night. When the residential entry team knocked at 4:49 a.m., Salcedo-Rios came to the door in a robe. He was arrested, advised of his Miranda rights, and transported without incident to the Metropolitan Detention Center in downtown Los Angeles. He said nothing to agents at the time of his arrest. He would not speak to federal investigators at any subsequent point prior to his eventual plea. The forensic processing of the Carson warehouse took 4 days and required the physical inventory and sampling of 1,347 individual drums. DEA chemists working under field laboratory conditions confirmed the presence of controlled precursor chemicals in the majority of samples tested on-site, with comprehensive laboratory analysis completed over the following 6 weeks confirming the specific chemical identities of the cargo. The compounds documented included acyl chloride derivatives, piperidine-containing synthesis intermediates, and, in the largest single lot, a cluster of 214 drums stored in a separate climate-controlled section of the facility, a quantity of phenylacetyl chloride sufficient, according to the DEA chemistry report, to produce approximately 1.4 metric tons of fentanyl at laboratory standard synthesis efficiency. The phone seized from the warehouse office, the one the third detainee had attempted to use before his arrest, turned out to contain an active messaging application linked to an account that HSI's digital forensics team, working with the device's content over the subsequent weeks, was able to associate with the individual identified in the Wiretap Intercepts as El Contador. The messages on the device provided independent corroboration of communications that had been intercepted through the court-authorized wiretap, and in several instances, they extended the documented record into periods before the wiretap authorization had been obtained. They also provided for the first time material that investigators assessed as potentially identifying for the cartel side principals, referrals that were incorporated into separate DEA and HSI international investigations. The financial seizure component of the operation ran parallel to the physical evidence collection. IRS-CI agents executed restraining orders against 23 bank accounts associated with Salcedo-Rios' shell company network. The accounts collectively held approximately $8.4 million at the time of seizure. A parallel civil forfeiture action, filed on the same day as the criminal indictment, sought recovery of an additional estimated $21 million in real and personal property, including the San Pedro residence, 2 investment properties in the San Gabriel Valley, a vacation property in Rosarito, Mexico held through a Mexican corporation, 3 additional vehicles, and the contents of a brokerage account held in the name of one of the Nevada shells. The full indictment, returned by a federal grand jury in the Central District of California on May 6, 2021, contained 27 counts. The charges against Victor Emmanuel Salcedo-Rios spanned multiple federal statutes and represented the full prosecutorial weight of the 5-agency investigation. Count 1 charged conspiracy to import a controlled substance, specifically that Salcedo-Rios had conspired with others known and unknown to the grand jury to import into the United States listed chemical precursors for the manufacture of fentanyl, a Schedule II controlled substance, in violation of 21 U.S.C. Section 963. The statutory maximum for this count alone was life imprisonment. Counts 2 through 14 charged substantive customs fraud, specifically the knowing and willful making of false and fraudulent statements in connection with the importation of merchandise, in violation of 18 U.S.C. Section 542. Each count corresponded to a specific documented entry identified during the investigation as having been filed with false HS codes. The 13 counts selected for charging represented a stratified sample across the full geographic and temporal range of the scheme's documented operation. Counts 15 through 21 charged money laundering, specifically the knowing concealment of the proceeds of specified unlawful activity through financial transactions, in violation of 18 U.S.C. Section 1956 A-B-1 B-I. These counts tracked the specific fund flows from the Chinese and Malaysian exporters through the shell company accounts to Salcedo-Rios' personal financial landscape. Count 22 charged operating a continuing criminal enterprise, specifically that Salcedo-Rios had, as an organizer and supervisor of a criminal enterprise involving at least 5 other persons, engaged in a continuing series of violations of federal controlled substances law, in violation of 21 U.S.C. Section 848. This count, the so-called Kingpin statute, carried a mandatory minimum of 20 years and a maximum of life. Counts 23 through 27 charged tax evasion for the years 2016 through 2020, in violation of 26 U.S.C. Section 7201, reflecting the estimated $1.7 million in unreported income that IRSCI had documented flowing through the shell company structure into Salcedo-Rios' household. 3 co-defendants were also named in the indictment. Jorge Albino Reyes Castellano, 41, the individual identified from the intercepted communications as Marcos, was charged with conspiracy to import a controlled substance and money laundering. DEA agents working with Mexican authorities arrested Reyes Castellano in Culiacan on May 8, 2021, 2 days after the indictment was unsealed, and extradition proceedings were initiated through the Mutual Legal Assistance Treaty process. As of the date of this file's partial declassification, those proceedings had reached a stage that cannot be described in this public release. Ernesto Figueroa Vargas, 53, a Wilmington-based freight forwarding company owner who had been identified during the investigation as a secondary broker involved in the falsification of certain documentation packages, was charged with 2 counts of customs fraud and 1 count of money laundering. He pleaded guilty to a single customs fraud count on September 14, 2021, pursuant to a cooperation agreement, and was sentenced to 32 months in federal custody. A third co-defendant, whose name remains redacted in this public release pending ongoing legal proceedings, was charged with 2 counts of conspiracy relating to the Carson warehouse distribution operation. Salcedo-Rios himself did not fight the charges. His defense team, engaged shortly after his arrest, entered into plea negotiations with the U.S. Attorney's Office. Those negotiations were lengthy and at several points appeared to reach an impasse over the government's insistence on cooperation requirements that Salcedo-Rios' counsel indicated their client would not satisfy. The final plea agreement, executed on February 7, 2022, almost exactly 1 year after his arrest, reflected a compromise. Salcedo-Rios agreed to plead guilty to Count 1, conspiracy to import a controlled substance, Count 16, money laundering, and Count 22, continuing criminal enterprise. He agreed to forfeit all assets subject to the civil forfeiture action. He agreed to provide a full factual proffer regarding the mechanics of the scheme and the identities of his domestic contacts, but was not required to testify against any individual in any proceeding. The cooperation requirement was, in effect, limited to documentary and historical disclosure rather than active testimonial participation, a concession that the government accepted in exchange for the certainty of conviction on the most serious counts. The sentencing hearing for Victor Emmanuel Salcedo-Rios took place on August 22, 2022, before United States District Judge Howard the 1000th Nakamura in Courtroom 8A of the Edward R. Roybal Federal Building in downtown Los Angeles. The proceeding lasted 3 hours and 40 minutes. The government's sentencing memorandum ran to 91 pages, including exhibits. It argued for a guidelines sentence of life imprisonment, noting that the adjusted offense level under the applicable guidelines range, when computed to reflect the drug weight attributed to Salcedo-Rios' conduct, the financial magnitude of the scheme, and his role as an organizer and supervisor, produced a range for which the statutory cap constituted the effective ceiling. The memo described the downstream consequences of the scheme in terms of the overdose data, a 34% increase in fentanyl-related overdose deaths in Los Angeles County over the same period covered by the indictment, a period during which the task force's retrospective analysis estimated that a meaningful fraction of the county's fentanyl supply had moved through the Carson distribution network. The defense's sentencing submission, by contrast, focused on Salcedo-Rios' personal history, his lack of prior criminal record, the absence of evidence that he had personally handled or used controlled substances, and what his attorneys characterized as his limited understanding of the ultimate downstream consequences of his conduct. The memo argued for a sentence in the range of 15 to 20 years, emphasizing the existence of cooperation through the factual proffer and the financial settlement. Judge Nakamura was not persuaded by the defense's framing. In a statement from the bench that lasted approximately 20 minutes, he described the conduct as occupying a unique category of federal crime, one in which the defendant had used the trust and authority vested in a federally licensed professional to systematically defeat a regulatory system that existed specifically to prevent the deaths of American citizens. The judge noted that Salcedo-Rios had not been coerced, had not been in financial desperation, and had not been deceived about the nature of his participation. He had, by his own factual proffer, understood precisely what he was moving and precisely what its end use would be. He had chosen, over a period of more than 3 years, to continue choosing to do it. Victor Emmanuel Salcedo-Rios was sentenced to 28 years in federal prison, to be served without the possibility of parole. He was also ordered to pay $14.3 million in criminal restitution and to forfeit all assets subject to the earlier civil action, with a final forfeiture order entered in the amount of $29.7 million. He was remanded to custody immediately upon sentencing and subsequently designated to a federal correctional institution whose identity is not included in this public release. He was 47 years old at sentencing. In the formal after-action assessment completed by the task force and submitted to DOJ's Organized Crime and Gang section in November 2022, the investigators identified 3 systemic vulnerabilities that the Salcedo-Rios scheme had exploited and that had been at least partially addressed through subsequent regulatory and administrative action. The first was the absence of a real-time cross-referencing function between CBP's entry processing system and DEA's chemical precursor registry at the time of entry filing. Salcedo-Rios' falsified HS codes had been filed against a system that flagged precursor imports only when the correct code was used. A broker who used a wrong code did not trigger the flag. The system assumed good faith compliance with the classification rules. Following the investigation, CBP and DEA jointly developed an enhanced review protocol, applying chemical descriptor text analysis to entry records using codes in the agricultural solvent and industrial chemical families, designed to catch descriptions that might represent miscoded precursors. The protocol was formally implemented as part of the Commercial Targeting and Analysis Center's standard operating procedures in early 2023. The second vulnerability was in the licensed broker oversight system. Salcedo-Rios had maintained his CBP broker's license throughout the entire period of his criminal conduct, never triggering a compliance audit or a license review. The investigation led to a formal review of CBP's broker audit procedures, resulting in an enhanced risk scoring framework for brokers handling high-volume chemical entries, with mandatory periodic audits for brokers whose accounts include entries in sensitive chemical categories. The third vulnerability, and the one that the task force identified as most consequential for future cases, was the opacity of the shell company network through which Salcedo-Rios had moved his commissions. The wire transfers from Chinese and Malaysian exporters to his domestic shells had passed through the US financial system without generating FinCEN suspicious activity reports, because each individual transfer was structured to fall below the threshold that would have triggered enhanced review. The task force's post-case analysis estimated that FinCEN's existing threshold structure had allowed approximately $4.2 million in criminal proceeds to move through the domestic financial system without detection. The analysis was incorporated into FinCEN's internal review of threshold structures for trade-based money laundering patterns, a review whose findings are not available for public release. The case is catalogued within HSI and DEA's shared intelligence systems under the case name Operation Tariff Ghost. The wiretap recordings, the forensic chemical analysis, and the financial mapping evidence remain sealed as intelligence material pending active international proceedings. The Carson warehouse was condemned and demolished by its property owner in April 2022. The building permit for the demolition describes the structure as having suffered extensive structural damage from deferred maintenance. Special Agent Theodora Kwan received a formal commendation from the HHS Inspector General's office in October 2022 for her role in initiating the investigation. The commendation cited her pattern recognition in an unrelated dataset as the proximate cause of the largest single chemical precursor seizure in the history of the Port of Long Beach. She was, at the time of the citation, already working on a new analysis project, a different spreadsheet, a different dataset, a different sequence of numbers that did not quite add up. The work continues. Case file 4471D is designated partially declassified. 14 attachments remain classified in full. The evidentiary record is maintained at the DEA Records Management Section, Drug Enforcement Administration Headquarters, Springfield, Virginia. Access requests from authorized parties may be directed to the Freedom of Information Act records desk of the participating agencies. This record is factually accurate to the extent of the material authorized for release. Discrepancies between this public record and classified attachments, where they exist, reflect the operational necessity of protecting sources, methods, and ongoing proceedings, not errors in the underlying case history. The chemicals were real. The people who died from them were real. The file is closed. End of case file 4471D.